Okay, so I want to welcome everybody to our educational program tonight, Estate Planning with Gary Altman. Gary is the founder and principal attorney of the estate planning law firm Altman and Associates, where he's been serving the Washington metropolitan area, practicing law and estate planning since 1980. A nationally recognized estate, legacy, and business planning authority, Gary's outstanding expertise, trustworthiness, and commitment to his clients' needs has earned him repeated recognition by Washingtonian Magazine and Bethesda Magazine as among the DC, Maryland region's best estate planners. He has also been repeatedly honored as a top 100 attorney by Worth Magazine and likewise recognized as a Maryland and Washington, D.C. super lawyer. Gary brings over 30 years of experience practicing exclusively in the estate planning area of the law. His depth of knowledge and experience has enabled him to counsel his clients in the generational transfer of wealth. Clients often seek Gary's advice on complicated estate matters. As an industry leader, Gary has taught various estate planning courses to attorneys, accountants, and financial planners. He continues to serve as a past president and chairman on the board of Hope Connections. Thank you, Gary. He maintains an active participation in both financial planning associations and continues charitable, civic, and faith-based organizations that enrich the community. Gary is a wine aficionado and enjoys barbecuing and making homemade brick oven pizzas for friends and colleagues. And Gary, we're thrilled to have you here with us tonight. I'm going to turn it over to you.
Thank you, Stephanie. Though I just realized I have to change my bio because I am no longer on the board of Hope Connections. Last year was my last year, unfortunately. All right, I'm going to share my screen. So give me a second because I don't do this well. Slideshow. We'll see. Let's see the slideshow. Hold on. There we go. Okay. All right. So you know who I am. I'm Gary Altman. My office is up the street from Hope Connections, about 5 minutes away. So I get asked a lot of questions from people. One of the first is, why do I need an estate plan? Or in other words, why do I need to pay you, Gary, to do anything? And the answer typically is that many people want to protect, preserve, grow their hard-earned assets for themselves, for their heirs, and maybe to create a legacy. And the other main reason is you've got to select the right people to make decisions for you if you can't. And another question usually is you have to decide who's going to receive your assets, and most importantly, how are they going to receive them? And a large part of this presentation is about the how people receive assets when someone dies. So when I first started doing estate planning, everyone asked me about estate taxes. Back then, the amount that passed free of federal estate tax was $600,000 or less. Today, the amount that passes free of federal estate tax is a little shy of $14 million for a single person or $28 million for a married couple. Now, a law was passed almost 10 years ago, which raised these limits to this amount, and it was thought that that law would expire by the end of this year. At this point, it's unlikely to do so, especially because the House of Representatives yesterday passed an extension of the tax cuts and the raising of these exemptions for another 5 or 10 years. If you live in Virginia, there's no Virginia estate tax. If you live in DC or Maryland, there is a state tax. The estate tax exemption in DC is a strange number, which is $4,873,200. Don't ask me how they came up with that. And in Maryland, if you have more than $5 million, if you're single, or $10 million, if you're married, there will be a state tax. Now, there is a bill inside the Maryland legislature that was just introduced a couple of days ago to limit that exemption to $2 million. And what's important about that is that if you're married, or if you were married and your spouse died within the last 5 years, you have the ability to inherit your deceased spouse's unused Maryland exemption. So, in other words, if you had a spouse and that spouse died in 2023, her exemption in Maryland was $5 million. Assuming you as a surviving spouse got anything, the deceased spouse didn't use any of the exemption. You could have inherited that exemption if you filed an estate tax return, but probably no one told you to file a return, and you would have thought, why would I file a return? There was no estate tax. Well, now it may be important to file that return from 2023 or 2022 or 2021, or, and I'll talk about 2020 in a second, if your assets exceed more than $2 million and you live in Maryland. So if your assets exceed more than $2 million and your spouse died after March 1st of 2020, you probably should file a Maryland estate tax return immediately in order to inherit your spouse's unused Maryland exemption. Again, since they may lower the exemption to $2 million, it may be very, very important to file this return. We've had clients who have said to me over the last 5 years, I don't need to file a return. My assets will never exceed $5 million. And we never thought they would lower it, but it's a very good shot that they will lower it. The Democrats in the Maryland legislature have wanted to lower it to $1 million. They put that bill in the last session last year. The Maryland governor wants to lower it to $2 million, and it may just happen. So again, if you have a spouse who died after March 1st, 2020, you should consider, if not definitely, file a Maryland estate tax return in order to inherit your deceased spouse exemption. Now, if your spouse died on March 1st, 2020, you only have until March 1st, 2025 to file the return. If your spouse died on May 1st, 2020, you have until May 1st, 2025. And I am telling you, it may take it's going to take time to gather the information and to file a return. So if you are in this situation, I really suggest you contact someone tomorrow, like me or like a CPA, to help you do this. We just found, it just was yesterday when they introduced the bill to the Maryland legislature. Went the wrong way. Okay, so why do you need to do estate planning? You have to name someone to make medical and financial decisions for you if you're unable. You may want to avoid the probate process and minimize costs and time. Many people need to create a comprehensive estate plan to preserve family harmony. What I really mean by that is that if your family gets together to have Thanksgiving dinner every year and you want it to continue, you better make sure your estate plan doesn't have a time bomb in it that will destroy your family's harmony and happen so they'll never have Thanksgiving dinner again. If you're married, you may be concerned that your spouse will remarry after you die and will decide that your surviving spouse likes her new spouse's children better than yours. And every one of us has a story of someone who that happened to. Many people want to protect their children's inheritance from problems like divorces, lawsuits, and creditors. I can't tell you how many times someone tells me, I don't want my money to go to my daughter-in-law. And you may have a child or an heir with special needs or other issues. Some people ask me about what is a revocable living trust. And a revocable living trust is a document which allows us to avoid the probate process when you die if your assets are titled in the name of the trust. It makes it simpler, less costly, less stress to transfer property at death. There are some alternatives to a living trust to avoid probate, and I'm going to explain why these may not be as good as a living trust. And one is joint tenants with right of survivorship. There's something called transfer on death. You do that on your brokerage account. You have a paid on death designation. That's for your bank account. And what that means is it says it's going to be paid on death to your son Joe when you die, and it goes to Joe. He doesn't have to do anything but provide his death certificate. If you have a account at Capital One, they use the phrase in trust for instead of paid on death, and it means the same thing. And if you have a life insurance policy, retirement account, or annuity, the beneficiary designation avoids the probate process. But there are problems. So next week, someone's calling me and wants to add their daughter as a joint tenant with rights of survivorship on their house. And they're going to ask me, can I do that? And I'm going to explain to that person that it's not recommended. And they're going to say, why is it not recommended? And I'm going to tell them that, well, if you put your daughter as a joint tenant on your spouse, and then she has a car accident, guess what? You could lose your house. If she has a financial problem, she could sell your house out from under you. If she gets divorced, it's quite possible her horrible spouse may try to get your house. If you have two kids and you leave your house to one, it may lead to family fighting. It could lead to something called accidental disinheritance. And there are times when someone dies, if we don't have enough resources, because everything's jointly owned, we can't pay debts or administrative expenses. I have this situation right now. We have a client who died who apparently never filed her income tax for the last 4 years. And all that's in her estate is less than the taxes that are due. And we may have to go to people who thought they were inheriting money and get it back because she didn't plan correctly. Okay? And one of the things she did is right before she died, she gave away $1 million to her friends because she thought that made more sense, and it didn't make more sense. The only positive to having joint accounts is that it's simple. It's simple, and it doesn't cost much, and it avoids probate upon death. And if it's a checking account, it allows your joint tenant to write checks. Now, we many times recommend to our clients that their checking account, it may make sense to have a kid on the checking account. There's not much money in it, but for your house, big brokerage accounts, big financial accounts, it really doesn't make sense. If the goal is to avoid the probate process, just do a revocable trust. Same thing happens with TOD, POD, ITF. You may not lose it because someone has a problem, but it may not do the right thing. It doesn't allow us to do planning. It doesn't give us money, and it may lead to family fights. I can't tell you how many times we've had a client die, and she has her a mutual fund or a bank account paid on death to a child, and her will says leave everything to 3 kids. And the next thing we know, the kids are fighting because they say mom didn't intend that. Okay. So if the goal of planning is to avoid problems and the goal of planning is to protect assets, don't do these things without advice. What else may be important? Well, besides a living trust, everyone needs a will. A will just says who gets your assets. But, I was talking to a client today who has a house in France. Well, a will is very important in that case because that the only way to transfer a house in France is through a will. You can't use a trust. And we need very specific provisions in the will to deal with the house in France. You need a document called a power of attorney or a durable power of attorney. And that's so you can appoint someone to make financial decisions for you while you're alive if you can't. You have to trust this person, okay? Because they have a lot of power. But it's a very important document. Many times these power of attorneys are effective when you sign them. Again, you really have to trust the person who you appoint. Sometimes they're only effective upon when you become disabled or incapacitated. That protects you somewhat, but it also makes it very difficult to use. Then there's a medical directive. That's a medical power of attorney, a living will. So that's where you appoint someone to make medical decisions for you, which could include the decision to withdraw life-sustaining treatment. There's something called a medical or HIPAA release. That's so the doctor will talk to the person who's making medical decisions. Then what's important for many people is you have to decide who's getting your stuff. Your jewelry, your artwork, your furniture, your china, your crystal, whatever it is, you need to make that decision. Okay? I can't tell you how many kids want to kill each other over their parents' stuff. Okay? You decide. Then in today's world, someone has to know your passwords and login informations. What is most important is someone must be able to get into your phone. Your phone controls everything. And someone must be able to get into your cell phone. If you don't have a cell phone, and I have some clients who don't have cell phones and don't use them, and that's okay. If you have any electronic accounts, someone has to have those passwords. And then you've got to make sure that the beneficiary designations of your retirement accounts and your life insurance are consistent with your estate plan. It doesn't do me any good. It doesn't do you any good for me to draft the most comprehensive will or revocable trust that defines exactly who's gonna get your assets and when they're gonna get them and how they're gonna get them. If you have someone else listed as the beneficiary of your IRA. And I'm gonna tell you a little story. So a client of mine's uncle died, and the uncle had a will, and the will said, give a little bit of money to my nieces and my nephews and a couple of charities, and give the rest of my money to these 3 organizations. Okay? His assets, when he died, included a retirement account and a little bit of assets. The little bit of assets will only pay the specific bequests. We need the retirement account to pay the charities. Well, one of his nephews is going to go to court to say that he should be getting the retirement account, the IRA, the $2 million, rather than it go under the will. There is no beneficiary designation of the IRA, so it would go under the will, but he thinks he was supposed to have been the beneficiary, and he's going to sue to get that. Okay? To me, it's important that everyone do planning so that whatever you want to see happen happens. And that means everything's got to be consistent and it's got to be done correctly and reviewed. Okay? And if it doesn't, the only people who usually benefit are lawyers, because we make all the money when people fight. And it's not fun money to make. Okay, why would you need a trust for your children or other heirs? And I'll explain more what a trust is in a little bit. So the choice normally when you're going to leave money to someone is, I'm going to leave it to them outright. That means they get the money in their pocket. They can do anything they want. Or I'm going to leave it in a trust where someone's going to control it and someone's going to be able to get benefits. Okay, that's really what a trust is. So if you had a minor beneficiary like a grandchild, we probably need a trust. If you have a beneficiary or special needs, we absolutely need a trust. Suppose one of your heirs, kids, has spending problems, okay? Someone told me today that if they gave money to their sister, she'd spend it all in 12 minutes. Okay, so we need a trust so that she doesn't spend it all in 12 minutes and it's there for the rest of her life. I have clients, and I know you know people who just can't handle life or money right now. Okay, and that if you gave them money, it would be wasted. And what's probably better than handing them a lump sum is to give them a stream of payments so that they will have money for the rest of their lives. I have clients who have beneficiaries who have drug or alcohol problems. Again, we need a trust for that. Suppose your heirs are perfect. They have no problems. They're wonderful. They have great jobs, great everything. But you know what? We still may want to protect them from a bad marriage, or a lawsuit, or a creditor, or future nursing homes, or future estate taxes. Okay? So we create many trusts for heirs who are wonderful, just to protect the inheritance. And then I hear this a lot. I love my daughter-in-law, but I don't want her to get any of my money. I want the money to go to my son, and when he dies, I want it to go to my grandchildren. Okay? We need a trust for that. And then for some people, you know, you want your nephew or your sister to use the money, but when she dies, you really want it to go to your charity, not hers. So again, we'll need a trust for that. So these trusts are all irrevocable. And again, to emphasize, the reason why we do irrevocable trusts for many of our clients is maybe to avoid an estate or gift or an income tax. But you got to have a lot of assets for that. To control a gift or inheritance, like a special needs trust, or to protect someone from predators or scams or themselves. Or we want to protect a gift or inheritance from creditors, lawsuits, divorces, bankruptcy, nursing homes. And when we protecting gifts or inheritance, sometimes the beneficiary is even in control and can have a lot of power, but it's still protected. The types of irrevocable trusts are, again, special needs trusts, discretionary trusts. Again, those are for people who can't handle money. Protective trusts, those are for people who can handle money. We just want to protect the inheritance. Sometimes we don't want to give our money outright to our spouse because we're in a second marriage. So we'll create a trust for our spouse, and that's called the marital or bypass trust. And then there are lots of types of irrevocable trusts that we need to avoid or minimize attacks. And if you have one of these situations, I'll be glad to talk to you. There are charitable trusts. I mean, you can leave your money into a trust that gives your child or your niece or your nephew or your spouse an income stream. And then when your spouse dies, it goes to your favorite charity like Hope Connections. Okay. Or we want to do it for estate tax savings, and those type of trusts are called, by the way, estate planning lawyers like me love acronyms, okay? These are all acronyms that mean something. So in the first line, it was a charitable remainder trust, a charitable remainder annuity trust, a charitable remainder uni trust, a charitable lead annuity trust, a charitable lead uni trust, or a private foundation. On the next line, it's called, these are estate tax trusts, and these are usually when your assets are more than the limit, and the limit again is close to $14 million for a single person, $28 million for a married couple. And those are trusts that are called a spousal lifetime access trust, a qualified personal residence trust, a grantor retained annuity trust, an intentionally defective grantor trust, and promissory notes and sales. Okay. Again, if you have assets and you need to do one of those, I'll be glad to talk to you, but it's probably most people in this call, it's not necessary. So what does irrevocable mean? Now, most of you think to yourself, I know what irrevocable means. It means you can't change the irrevocable trust because it's irrevocable. Well, that's what it used to mean. It doesn't mean that anymore. Irrevocable trust does not mean you can't change it. It just means that it can't be changed without cost. That means legal fees, time, and energy. Okay. And there are many ways to change irrevocable trust. And I can tell you, we change irrevocable trust probably 30 to 50 times every year now. Okay. So we can do it by going to court. We can do it by the action sometimes of the people named in the trust or the words of the trust. And we can do it by everyone agreeing, and we can do it by what's called the decanting. And a decanting is changing the words of an irrevocable trust and changing them sometimes into a new irrevocable trust and giving everyone notice of it, but not getting their consent or permission. Okay, it's sort of like that old phrase, I'd rather do it and ask for permission later than ask for permission in the front. If I'm doing a family settlement agreement, I got to get everyone's consent or permission before I do it. If I'm going to go to court, I got to get everyone's permission first. But in decanting, I don't need their permission. I'm seeking their forgiveness once I do it. And if most people are okay with it, because they don't want to fight. A little bit more about special needs trusts. The whole purpose of a special needs trust, if you have a beneficiary who is going to have government benefits, we need to create a trust to hold the property for their benefit so that it won't disqualify the beneficiary from needs-based government assistance. Okay, and there's something called an ABLE account, and many times the special needs trust and an ABLE account work together. A spendthrift or discretionary trust, again, is created for a beneficiary who can't control their own spending. All full authority is given to a trustee and someone who is not the beneficiary. Creditors of the beneficiary can't access the funds. Alimony and child support may be possible. The IRS can reach almost anything. And in some places, food and shelter sometimes can be forced out of a trust. So, but in most states, creditors cannot reach a irrevocable trust, especially with an independent trustee. A protective trust, depending on the state law, if the beneficiary is the trustee and the distribution to the beneficiary is limited to something called health, education, maintenance, and support, the beneficiary's creditors can't get to the trust assets. That's true in Maryland, DC, and Virginia. And the beneficiary can have very broad power to do a lot of things. There are estate and potential income tax savings. Many people call these protective trusts legacy trusts, dynasty trusts, generation skipping trusts. So don't worry about what the name is. It's really an irrevocable trust for a beneficiary. So do you need to create a trust for your spouse? And the answer is yes. If you live in DC or some other place, you may need it for estate taxes. Or if you're in a second marriage, or if you're worried about a second marriage and you want to protect your children. And if you're worried about if your spouse will change your distribution, either intentionally or unintentionally. Look, I can give you many stories of people whose spouse have died, and then they come to me and change what they and their spouse agreed to a week ago. Okay, it happens. Okay, it happens. So if you want to make sure that it doesn't happen, you have to plan for it. Okay, if you don't want to trust for your spouse and you want to protect your children, what do? Well, if you were young enough, you can buy a lot of life insurance just to give to your children, or you can split your assets, some to your spouse, some to your kids, or you sort of hope for your best. Okay? And so I'm going to tell you about my dad. My dad was married for a second time. His wife, who was not my stepmother, she was my father's second wife, didn't like his kids. And my father, unbeknownst to me, created a trust for her benefit, which was the right thing to do. But the wrong thing to do was he named her as the trustee. So my father died in 1997. I don't know how much money was put into this trust for his spouse because I was never even told it existed until she died in 2022, 25 years later. Okay? So I have no clue how much, but all that I know is that when my father's wife died in 2022, I received $11,000. Now, I am sure there was much more than $11,000 put into the trust in 1997. And since 1997, the average investment return in the stock market has been over 10%. And if that money, whatever it was just done in a way that was respectful for his children, I would have received a lot more than $11,000. But he told me before he died that he thought that his wife Lois was going to do the right thing. And I don't think Lois did. Okay, so many of us have retirement accounts, IRAs. Okay, and most of you have already started your distribution schedule, so I don't have to tell you what it is. You know, when you take money out, you got to pay income tax. How can you avoid it? The only way to avoid it is called a charitable direct contribution, something like that. I'm drawing a blank on the name. Basically, you can take up to $100,000 of your IRA and give it directly to charity each year, instead of taking your required minimum distribution. So you don't pay income taxes on it, the charity gets the money. And it doesn't increase your adjusted gross income, so that could help you avoid income tax on your Social Security. Okay, so it's a good thing if you want to give money to charity. Okay, you could have, and you still could convert some of your IRA to a Roth IRA, and if you convert it to a Roth IRA, neither you nor your heirs have to pay income tax on it. What happens when you die? Well, again, if you have a spouse and you name your spouse as the beneficiary, she has lots of options. And she can take required minimum, or he can take required minimum distributions over his or her lifetime. But again, the surviving spouse can name whoever they want as the beneficiary. The dead spouse has no control unless you could create a trust. Okay? And then you can control it. Again, if you don't want to trust, buy life insurance, maybe give your kids part of your IRA, or you hope for the best. Okay? And if you don't have a spouse, who should be the beneficiary? Well, it shouldn't be your estate. It shouldn't be a minor. It shouldn't be someone with special needs or other concerns. So either you need a trust, or if you have very good, responsible beneficiaries, you can name them directly. And no matter what you do, whether you name them directly or create a trust, they have to take it out over 10 years or over their lifetime if they have special needs. So a special needs trust still gets lifetime. Everyone else gets 10 years, whether it's a trust or outright. Okay, again, they have to pay income tax when they get the money. Some people, we create charitable remainder trusts to be the beneficiary. So your beneficiary gets income for their life and then it goes to charity. That allows us to defer some income tax. I have a lot of clients who give their entire IRA to charity. And if you had a Roth IRA, that means you pay the income tax up front. Your beneficiaries don't pay when they withdraw. Isn't that wonderful for your beneficiaries? Okay, electronic accounts and records. Again, you need special provision in your will and power of attorney to allow them to access it. There are laws, but those laws specifically state you need a provision in your will and you need a provision in your power of attorney so that your executor of your estate or your power of attorney can access your electronic records. Email accounts are not transferable. A lot of things are not transferable, and without passwords and PIN numbers and logins, some people may never be able to get to it. And so it's very, very important that someone does. If you have a Kindle account, if you have a Barnes and Noble account and you have books, or you have a account with Apple and you have songs, those are not transferable. But if someone has your login information, they can, in essence, continue to use it. And you didn't hear me say that. All right. Estate planning is not a one-time event, or it's not a product. It's really a process. And a good part of my life is spent talking to my existing clients about changes that happen in their lives, or changes that happen in the law, or changes that happen in the tax law, or changes that happen in their assets, and what we need to do to review and change it and keep it up to date. I believe that every 4 years people should review their documents. It's very important. And actually having a relationship with someone is really important. You know, this afternoon I had a call from a client's son, whose mother died in 2020 and had a very complex estate plan. And as he said on the phone to his banker, that if I wasn't around, it would be almost impossible to figure out what happened when his mother died. But because he has a relationship with me and has for the last 5 years, and his mother had one for decades, we know what went on. We have all the records. You know, all we have to do is look at them to find out. It's very important that someone knows what your situation is, your assets, where they're located. Who's your CPA? Who's your doctor? So that they can help you if you need help. And I will take questions. And there's my information. And I will take questions. If anyone has any question, if not, we can go home and I can eat dinner. You can either ask